Hello, I'm Hovik Manucharyan, and today is 11th day of the complete blockade of Artsakh by the regime in Baku. This is a collaboration between Armenian news network Groong and 168 Hours to bring more English language coverage on this very important issue. And our guest today is Aram Orbelyan, an international law specialist who is an attorney and managing partner at Concern Dialog, a law firm in Yerevan, and he's PhD in public international law. Mr. Orbelyan lectures at the Academy of Advocates of the Republic of Armenia, as well as the French University of Armenia. And Mr. Orbelyan was also the Minister of Justice of Armenia between 2011 and 2014. Thank you for joining us, Mr. Orbelyan. We have a very long list of questions for you today.
Thank you for the invitation. If you don't mind, let's go ahead with Aram.
Okay.
It would be more convenient to discuss in that way. And thank you for inviting. I believe it's very important to have different language material for dissemination worldwide.
Very good. So let's begin with the most recent issues, such as on Monday, the United States Security Council had a meeting at the request of Armenia to discuss the situation around Artsakh and around the Berdzor or Lachin corridor. We heard a lot of statements from different UN Security Council members demanding the reopening of the corridor, some describing the act of a blockade and saying that it contravenes international law, but not specifically naming Azerbaijan. But all what we heard were announcements. We didn't hear about any resolutions or condemnations specifically of Azerbaijan. In general, what tools does the UN Security Council have to compel Azerbaijan or any other actor that in a similar situation to reopen, for instance, the Lachin or Berdzor corridor?
Just a small correction, not US, but UN Security Council.
Did I say yes?
Yeah, it's just a typo. So, very important question. So, we really need to understand what was the meeting about, how it came to life, and what was the basis for having the meeting, convening the meeting, to be able to understand what happened there. Technically, anyone can go to the UN webpage, un.org, look at the Security Council section there, find the agenda, and see that the meeting was convened based on the letter from Aram Orbelyan from September 13th. Everyone, or at least people who are following, can recall that on September 15th there was another meeting where, again, members of the Security Council have raised issues connected to the Azerbaijan aggression against Armenia, or whatever they call it, border incident, etc. So this is a very important element to understand. So technically, the basis for the meeting was following up. So technically, this was a following up meeting after events of 12, 13, 14 of September, which happened on Armenia-Azerbaijani borderline. I wouldn't call it border technically. It's in Armenia we use it shepmangit, so the place of
line of contact.
Line of contact. So technically. From this perspective, it's very important to understand what does Armenia wants from Security Council, because technically the event was the meeting was convened by request of Armenia. Armenia was party to the meeting because, according to the rules, Armenia and Azerbaijan were called to join the meeting because we are not member of Security Council. Azerbaijan is not a member of Security Council, but both representatives were present. And technically, we are the initiator, so technically we should be requesting something. And for that, everyone again can go to the webpage and download the letter based on which the meeting was convened. And there is a letter from 13th of September from Meher Markarian, that's our ambassador to the UN, which as an annex has a letter from Aram Orbelyan, who is a Minister of Foreign Affairs. And what we requested here, we also expect that the Security Council, and there is a description what's happened on September, and then it's in the ending what we say, we also expect that the Security Council will condemn the aggressive actions of Azerbaijan in the strongest terms and will directly call upon Azerbaijan to unconditionally cease hostilities and respect the trilateral statement of November 9, 2020. So this is kind of technically what we requested. So what could have been done more, and what can Security Council do? United Nations have 6 major bodies. One of them is Security Council, and Security Council is the main political body who is responsible for international peace and security. So technically there is General Assembly, which does everything. There is International Court of Justice, where we have a court case. There is Economic and Social Council, which deals with economic social issues. There is Trustship Council, which is not convening anymore because we don't have non-self-governing territories since 94, and then we have a general secretary and secretariat, which is kind of dealing with all the staff of all the bodies. So Security Council is the body which is responsible for international peace and security, and chapter 5, 6, 7 are dealing with the authorities of the Security Council in the UN. Chapter 7 is covering so there are different authorities connected to the self-governing, governing, election of people, etc. But there is one chapter, which is chapter 7, which is speaking about action with respect to the threats to the peace, breaches of the peace, and acts of aggression. So there is a whole chapter which is telling what shall be done, and namely Security Council, what can Security Council be doing when there is these three situations: threats to the peace, breaches of the peace, and acts of aggression. And namely, if you go to the article, there is Article 39, Article 40, 41, 42, and it comes from the milder intervention, that is kind of recognition of a situation as such, to the more severe one, 42, which is speaking about should the Security Council consider that measures provided for in Article 41, and 41 is more or less economic sanctions, would be inadequate or have proven to be inadequate. It may take such actions by air, sea, or land forces as may be necessary to maintain or restore international peace and security. Such action may include demonstrations, blockade, and under operations by air, sea, and land forces of members of the United Nations. So, starting from the recognition of a situation, we are telling, oh, you did bad, this is aggression, this is threat to the peace. Then economic sanctions, calling other actions to be undertaken, and then in the end you bring forces.
Right.
Just for the audience, Article 42 never was used. So technically, UN never applied Article 42. There were different actions which are falling under different regulations, so-called peacekeeping forces. But peacekeeping forces in general have specifically different mandate, which is not directly falling, let's say, between 39 to 42 articles, which I said. Okay. We'll come back to peacekeeping at a little bit later stage, I believe. We will have questions. So technically, UN Security Council could have done several things. Firstly, they could have adopted a resolution. I will discuss how the resolution would be adopted. They could have a statement. That's the second one. Then there are milder versions, which are not a decision of the Security Council. That's a press release, and furthermore, there is a statement by the president. Okay. But if you take the two first documents, which are considered to be documents of Security Council of binding nature.
So the resolution and the statement, is that what you're saying? So
presidential statement is a specific form of a resolution which is adopted unanimously. If everyone agrees, so it's kind of has a number S/something, which is considered to be a decision of Security Council as well. It's called statement, but it is a Security Council decision.
So only like the first two versions that you talked about, which is the resolution or the presidential statement, would be considered official.
Those are the documents which have kind of binding force. Okay. And according to the UN Charter, I think paragraph, just to be sure that I'm citing the correct one, Article, just a second. According to the UN Charter, there is a paragraph, part 25, which states the members of the United Nations agree to accept and carry out the decisions of the Security Council in accordance with the present Charter, which means whenever there is a decision of Security Council, it is binding, politically binding, legally binding. Contrary to, let's say, decision of or resolutions of the General Assembly, which are not legally binding. It has, depending how it's adopted, it has a huge political power, but still it is not binding legal document. Security Council decisions are legally binding. Now, coming back to the topic, according to the rules of procedure, and this is actually provisional rules of procedure, it's never, since establishment of UN, the rules of procedure of Security Council never have been finalized. It's still provisional. That allows to be a little bit flexible, because because it is provisional, Security Council can a little bit deviate from that. Has a specific rules which states that a party which is joining, which is not member of Security Council, but which is joining the Security Council according to Article 37, I believe, has a right to propose a draft resolution. It have to be seconded or proposed by one of the members, but technically there is a possibility to bring in a draft. And any other member of the Security Council can initiate resolution process. We see that this didn't happen.
Right.
Neither Armenia nor Azerbaijan nor any of the members of Security Council initiated the process of the adopting of Security Council resolution. So now Armenia could have done it. There are two possibilities why Armenia didn't do it. Firstly, maybe politically we understood it will not pass.
Right.
Secondly, we didn't do it because we didn't want it, for different reasons. And coming back to the main topic which I started, it's very important to understand what is Armenia willing, what is the wish of Armenia, what is the request of Armenia,
Yeah.
what does Armenia as a state request from, let's say, international community or UN or other states. We need here to understand that international law is primarily law between states. It's not primarily law between people. Of course, international law, international human rights has very big implication on the day-to-day life of people. So as a person, when I go to court, I'm citing European Court of Human Rights decisions. Right. Or I'm citing ICCPR, the International Covenant of Political and Civil Rights, or any other document. But this is kind of part of the national law. Whenever I go to court, I use it.
Yes.
Whenever we speak about international diplomacy, whenever we speak about international relations, whenever we speak about UN, Security Council, international peace, international threat to the international peace, aggression, etc., we are using a law which is developed and implemented between the states as collective actors. So technically what you, me, any other people are doing is of importance from political point of view, is of importance from demographical point of view, from diplomatic point of view, from social, whatever point of view, but not from the international law point of view. Who is acting on behalf of the states? Technically, those are people who are, by their constitutions, right, given power to do it. Usually, it's considered to be three people: head of state, head of government, minister of foreign affairs. We can call it different ways. It can be president, king, prime minister, chancellor, whatever you can call it, and Minister of Foreign Affairs, State Secretary. So those three tasks, so those three people kind of are deemed to be people who are representing a state as a collective state. So those three people are responsible to represent state, and they are those people who are giving also authority, power for ambassadors, heads of missions to be representing us in different international relations. So technically, we need to come back and understand what is request of Armenia, and that is where I see the biggest problem.
Yes.
From the documents which I read, from the document which I follow, from the documents, statements, etc., which I see, I mean internal documents, I see that the government coming to the Artsakh issue is not telling, okay, you recognize self-determination of Artsakh, you recognize independence of Artsakh, you recognize interim whatever status of Artsakh before we finalize self-determination. They never speak about statehood of Artsakh. I have the feeling, again, it's from the documents. By telling feeling, it doesn't mean that it's hearts or not. I mean, I have the understanding that the government of Armenia is telling, okay, guys, this is yours, deal with it, we don't care about it, you Russians, Azerbaijan, Armenians living there, please, if possible, don't hurt the Armenians. Yeah. And please just don't do genocide. And then, if possible, please go away from our territory, which is our because we believe it's our, right? I mean, September events. So this is completely, and if this is the case, this is completely non-acceptable. We need to understand that there is quite a lot of international jurisprudence which would be assisting us to recognize Artsakh, which would be assisting us to recognize Armenian territory, which would be beneficial for Armenia whenever we would be speaking about delimitation, demarcation of Armenian-Azerbaijani border, which would be very beneficial when we would be speaking about human rights issues, etc. So this is a topic which we will be covering now, but this is very important element, and we need to look at this jurisprudence. We need to protect the rights and interests of Republic of Armenia, Republic of Artsakh. This is also very important because, please.
So let me just to remind our viewers and listeners, the official stance of the current, de facto authorities of Armenia seems to be that, they are open to not mentioning the status of Artsakh, at least in the final peace agreement between Azerbaijan and Armenia. And they said, they may sign it without such. And, at least from their public gesturing, it can be deduced that the status of Artsakh is not important. And as you mentioned, the letter that which was used to initiate this meeting, it cited the events of September 13, 14, I guess, and not specifically concerned about the conflict in the corridor in November 9/10.
Yeah,
is that what you're saying?
Well, let's say the process is the following. Whenever this letter was filed,
Yes.
let's simplify, a file was opened. So let's say there is a file. There is a dispute between Azerbaijan and Armenia. Why I'm telling this? Because I will cite another paragraph. It says the unilateral actions of Azerbaijan constitute a real threat to international peace and security. Real threat, not aggression. Because in the top, we read that aggressive war, aggression, etc. But I'm speaking here security, and deserve a strong and timely reaction from the international community. With the present letter, I kindly request an emergency meeting of the Security Council on the basis of Article 35, Paragraph 1, I will tell what it is now in a moment, of the Charter. I also kindly request the participation of the representative of Armenia in these deliberations, pursuant to Rule 37 of the Provisional Rules of Procedure of Security Council. The Rule 37 says, okay, when there is a dispute and the party is not member to Security Council, they should be called. Now, let's see what does the Article 35 of the Charter say, because this is also very important to understand what was the basis for our process. If you go to Article 35 of the UN Charter, this is a document again where which is regulating the actions of the bodies. As I said, there is a chapter which is Chapter 7, which says that United Nations Charter Chapter 7, actions with respect to the threat to the peace, breaches of the peace, and acts of aggression. This specifically says what we do when there is those three situations. There is another chapter which says specific settlement of disputes. It's international law. In international law, there are several principles, and one of them is that when states have disputes, they have to settle those disputes peacefully. And there is a big chapter which says how it's done, what are the types, what kind of activity should be dealt with. Article 35, which is the basis for the letter, at least that's physically what it is stating, is that any member of the United Nations may bring any dispute or any situation of the nature referred in Article 34 to the attention of Security Council or of the General Assembly. Article 34 is stating the Security Council may investigate any dispute or any situation which might lead to international friction or give rise to a dispute in order to determine whether the continuance of the dispute or situation is likely to endanger the maintenance of international peace and security. Guys, we are in the middle of a war, we are subject of aggression, our neighboring country is occupying our territory, is blockading people, is undertaking illegal armed activities on the territory of Armenia and Artsakh, and we are telling, there is a dispute which, by the way, may be threatening to security and peace. I want to recall, if the letter was from yesterday, from 10 days ago, it might have been, okay, there is a situation, we kind of settled at the moment, and then there is a blockade, this is the situation. This letter is from September 13, when we are in the middle of war. Okay. In the text, we are speaking like war of aggression against Armenia and Nagorno-Karabakh in 2020. We are not speaking about aggression in 2022. We are speaking about that Azerbaijan is breaching their obligations under Article 33, which is telling that they have to be dealing with the dispute peacefully. But in reality, what we have an act of aggression, we have illegal use of force, and we will discuss about different mechanism afterwards. I will come to aggression now, but when we are speaking, why doesn't CSTO act? Guys, if we are telling there is a small dispute on the border, CSTO
which might or might not, result in it.
It's very important to understand from a legal perspective, what are the actions of Azerbaijan? Not only blockade, but also all what is happening in Armenia and in Karabakh or in Artsakh. So there are two documents which are resolutions of General Assembly. One is so-called Declaration of Principles of International Law. There is a big continuation, but this is kind of a let's say cornerstone document, which is, as I said, General Assembly resolution. As a General Assembly resolution is not binding. So technically it's not legally binding document. However, there is a jurisprudence of International Court of Justice in at least 5 to 6 cases, if not more, the court has stated that this document has kind of embodied the principles which are of customary nature. I don't want to go too much in detail of international law, but technically, if it's of a customary nature, it's the same as it's legally binding.
Okay.
And whenever one of the parties would say, by the way, paragraph whatever is not of customary nature, that is the party citing that this paragraph is not of customary nature should prove vice versa. Usually you should do the contrary. Whenever you go to court and say there is a custom, then you have to prove. Well, the court said, okay, if you are citing here, then it is customary unless the party would be able to prove contrary. And the second document is a definition of aggression. I will come to that afterwards. There are several principles which are of importance, and this is kind of whenever we speak about principle of self-determination, when we speak about settlement of integrity, when we say about principle of peaceful settlement, it comes from here.
Okay.
Before going here, small spoiler, there is no principle of territorial integrity. I will come where it is and what is under which subparagraph it is stated. There is no such principle. Whenever we were speaking about previous documents, we always raised a principle document, a principle which was telling that all the disputes should be solved peacefully. And this was the major element which we were raising during the negotiations constantly all the time. We were not the territorial integrity, self-determination, human rights, those were not the initial or the parametric elements of the negotiations process. We were telling we are ready to discuss everything, but only peacefully. Now, let's see what is the principle. The first principle, which is telling that the principle that states shall refrain in their international relations from the threat of or use of force against the territorial integrity, that's where it is, or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. By the way, this text is from Charter of the United Nations, paragraph 2, subparagraph 4. Article 2, paragraph 4. So what it says, under it, I will not read all of it, but I will read 30% of it because it's important. Okay. A war of aggression constitutes a crime against the peace for which there is a responsibility under international law. And this comes from Nuremberg principle. This comes after Second World War. We said, okay, guys, aggression is a crime. Aggression is not allowed. In accordance with the purposes of principles of United Nations, states have a duty to refrain from propaganda of war of aggression. We see Azerbaijan constantly stating, if you don't do this, we will use our force. Our forces will do this. If you don't do it, we will do, our forces will force you to do something. Our forces will open the Zangezur corridor. Our forces will force you to do something. Yes. Every state has a duty to refrain from the threat of use of force to violate the existing international boundaries or another state, or as a means of solving international disputes, including territorial disputes and problems concerning frontiers of states. Now I will come to the next one, which is the most important one. Everyone is missing it, because when we say there is no border between Armenia and Azerbaijan, people say, oh, if there is no border, Azerbaijan may legitimately use it. Firstly, as you see, there is no legitimate use of force. Force is forbidden always. But then every state, likewise, has a duty to refrain from the threat or use of force to violate international lines of demarcation, such as armistice lines, established by or pursuant to the international agreement to which it is a party or which is otherwise bound to respect. What is armistice line? Technically, when there is an armistice, which means cease of hostilities, people agree that there is, okay, end of hostilities, we stand here, and there is a line of whatever forces are, and this is not a border, because there is a continuation, because these lines are not without prejudice to further status. Okay. But using force to breach those lines is also forbidden. I will bring an example for you to be more or less clear what we are speaking of. On the 38th parallel, in Korean Peninsula, there is a line between North and South Korea, or Republic of Korea and People's Republic of Korea. There is no border, there is no peace agreement, there is no agreement that this is a state border of those two states. There is an armistice agreement, if I'm not mistaken, by Paris Accords or by other procedures. Breaching those lines would be a crime. Okay. There is a similar border or armistice line between Japan and Russia, or Japan and Soviet Union before that, after Second World War. Second World War finished, there was a major armistice signed on 2nd of September, so there was a capitulation of Japan. There is no peace treaty, and Japan believes that Kuril Islands, Northern Kuril Islands, and part of the Sakhalin are Japanese territory. Russia believes it's Russian territory. Neither of the parties, so let's say if Japan decides to, let's call it, free its historical territory, it will fall under this line. Now coming back to our situation. 1994, 12th of May, there was an agreement between three parties. Nagorno-Karabakh, at that stage Republic, Azerbaijani Republic, and Republic of Armenia. Signed by those three parties, and it was considered to be basis for end of hostilities between those states, for three states from different areas, because the war is not bilateral. There are different dimensions there, or was. And that means that from 94, breaching those lines was act of aggression. 2020, actions of Azerbaijan was act of aggression. Armenia should have acted in that case, telling that Azerbaijan is undertaking aggression in that perspective. The next one was armistice lines established by agreement, or let's say announcement of November 9, where it explicitly states that the forces stay where they are. After that, Azerbaijan has occupied Khatsabert and surrounding areas. Armenian forces has withdrawn. Another document was signed or was not signed, I'm not sure, between Armenia and Azerbaijan. Azerbaijani forces occupied also Armenian Worotan and surrounding territories.
Yeah, Goriskap highway.
Which according to the armistice agreement was not there. So technically you have armistice, you agree, you have a final settlement, and the forces can go forward, backward. You need to have a delimitation and demarcation of the borderline already in a peaceful situation, not when your soldiers are standing there or occupying a territory. Another one, every state has a duty to refrain from any forcible action which may, and this is also very important, which deprives people referred in the elaboration of the principle of equal rights of self-determination of their right to self-determination and freedom and independence. Using of armed force to deprive people to exercise their rights of self-determination is an act of aggression, or at least is forbidden under this document, this instrument. Another one, the territory of a state shall not be object of military occupation resulting from the use of force in contravention of the provision of the Charter. The territory of a state shall not be object of acquisition by another state resulting from the threat of use of force. I will not cite all of them, but you see that there is a huge body of jurisprudence which allows claim that Azerbaijan is an aggressor state. Azerbaijan is an aggressor country which has occupied Armenian territory, which has occupied Artsakh territory, which is claiming that Artsakh is part of Azerbaijan, while there is a dispute, and I will come where the dispute comes from. We can see in this document there is a principle of equal rights and self-determination of peoples, which specifically states that the right of freely to determine without external interference their political status and to pursue their economic, social and cultural development, and every state has a duty to respect this right in accordance with the provisions of the Charter. There is a huge body here also below stating what it is. There is a small paragraph in the end. It says that the main purpose is not to, let's say, fall apart, to make states fall apart, but technically, if there is self-determination of people, it should be done in a peaceful manner. Now, there is also a very important element. As I said, there is no principle of territorial integrity. There is such principle in Helsinki Final Act, which is not legally binding document, but political document, which is speaking about inviolability of frontiers, which is still in our case is a little bit different story, because when we are speaking about independence of Artsakh, we need to understand from whom Artsakh is getting independent or has gained independence.
Exactly, that's also a major question. And from whom? Yeah, is it from the USSR, from Azerbaijan, or even maybe...
there are two possible answers. It's either from USSR or from Armenia.
Yes, because...
It cannot be from Azerbaijan for different reasons. I will explain why. Let me go to the aggression, and then I will come back to the independence of Artsakh. There is another document which is explaining what is aggression. So it's Resolution 3314, which is giving a definition of aggression. As I said, aggression is one of the cornerstones of United Nations, because United Nations was built after Second World War and after Nuremberg principles, and basic elements of like, we don't want any more aggressions to happen. It's not even a war, it's not even an armed conflict, but the aggression was kind of principal element. That's why we see in the documents they are speaking about threat to peace, breach of peace, and then act of aggression. It's also very important to understand if we don't have border delimitation between Azerbaijan and Armenia, could Azerbaijan be an aggressor state? So technically Azerbaijan is telling, oh, this is not your territory is somewhere there. Would he still be an aggressor or not? And the second argument which they are claiming during the session in United Nations, the one on September 15 mostly, what they say, we said we were acting against legitimate targets. We were just shelling the armed forces. There were some civilian casualties, but mostly we were targeting the legitimate military targets, which would be the armed forces. So let's go to several elements. Paragraph 1, and then they said, okay, we are adopting what is aggression. Paragraph 1, aggression is the use of armed forces by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of United States, Nations as set out in the definition. And then what is very important, it is, so in the definition in the term state, as stated, they're given an explanatory note. It's written, is used without prejudice to the question of recognition or to whether a state is a member to the United States and the nations. So what says, you recognize, you don't recognize, it's a member of UN, it's not a member of UN. Use of armed forces against a state is an aggression. This is one thing. Second one, the first use of armed forces by a state in contravention of the Charter shall constitute prima facie evidence of an act of aggression, although Security Council may decide it's not an aggression. So if one state uses armed forces against another state, first, then it's connected to be considered to be aggression, at least unless the Security Council of United Nations would say, okay, there is no enough gravity to consider it as an aggression, it's a border incident. Another one, which is also very important, the invasion or attack by the armed forces of a state of a territory of another state, or any military occupation, whatever, however temporary, resulting from such invasion or attack, or any annexation by the use of force of the territory of another state, or part thereof, is an aggression. Bombardment by an armed forces of a state against the territory of another state, or the use of any weapon by a state against the territory of another state is an act of aggression. Any attack, and this is also most likely even the most important one, an attack by armed forces of a state on the land, sea or air forces or marine and air fleet of another state. So if you have air forces, if you have, we don't have marines, but if you have land forces and armed forces of one state is attacking the armed forces of another state, this is an aggression. Yeah. So technically... So
based on Azerbaijan's own reasoning...
is an aggression.
Yes.
So here, and then there is a kind of description, just to be very frank and to be very fair, it still doesn't mean of self-determination is not applicable. So whenever there is a discrepancy who started first, then it might be questionable who is the aggressor. But then if you have a self-defense under Article 51, you need to understand if it was proportional to the purposes. So there is quite a lot of issues to be discussed. But now coming back to the situation, we have a situation around all Armenia, Artsakh, Azerbaijan. We have a dispute between Armenia and Azerbaijan at the moment, because technically there is a land which Armenia claimed to be Armenian land.
Yes.
And I will bring a very specific example, and Azerbaijan claims it to be Azerbaijani land. That means we have a territorial dispute. We are afraid to telling that. But that's not an Artsakh issue. We have a territorial dispute between Azerbaijan and Armenia. This should be settled peacefully, because there is a person who has a deed of property of a house in Shurnukh.
Yes.
I'm just bringing as an example.
And the government of Armenia has given that deed.
And now government of Armenia kind of say that this might be not Armenia. Let's say, technically, because I'm not going even to the other territories, other claims. We are telling that there is a place where a person has a deed from Armenian government which considered to be Armenian territory. Now Azerbaijan is claiming it to be Azerbaijani territory. This is a clear territorial dispute, and Azerbaijan is solving this territorial dispute by use of force. So because people came in to someone's house, at least that's what the information is there, said, listen, if you don't go out, we'll take you hostage or we'll kill you. Person get out, and the Azerbaijani soldiers headquartered there. This is one dimension which is to be discussed. And that's also Vorotan or Goris Kapan's road. Goris Kapan road was built by Armenian funds, I mean Soviet Armenia,
yes.
It was always under Soviet Armenian control. Soviet Armenian so-called GAI, the police was patrolling there. Soviet Armenia was undertaking all the activity there. So technically the road should be Armenian. But this is kind of one dimension. So one of the dimensions is Armenia-Azerbaijani dimension. As I said, there is a territorial dispute issue, which is clear. I mean, people are afraid telling, oh, there is no territorial dispute. There is territorial dispute between Armenia and Azerbaijan, at least today. But that's not Artsakh. That's completely different story. There is a second dimension, that's an Artsakh independence, which is, in my opinion, already a fact.
Yes.
But today, Armenia is going back again, telling, oh, maybe it's not, maybe it's territory, maybe security or people living there, Armenian population. People who studied in Armenian schools, Armenian history, could remember, and the numbers are vice versa, that's why a lot of people remember it very well. So there were two main conferences with Ottoman Turkey, and then there was Article 16 and Article 61. Article 61 in Berlin completely came back from the Article 16 of, if I'm not mistaken, San Stefano, or one of the conventions or agreements where Armenians were given self-government, and then they say, oh, there is a population of Christians, Armenians should be kind of followed, etc. So we are kind of in the same trap situation. We need to really understand what happened in 91. In 91, Soviet Union collapsed. And in 91, some states appeared on the territory of Soviet Union. In 91, some states claimed their independence. And then we need to look at, okay, Azerbaijan proclaimed their independence, Armenia proclaimed their independence, let's say Soviet Russia or Russia proclaimed their independence, and all other countries. It's not clear under which logic we should decide that, let's say, Soviet Armenia became independent Armenia. From international point of view, and that's also very important, we need to set back a little bit from cultural, let's say, day-to-day understanding of Soviet Armenia. From international law perspective, there was one subject of international law, and that was Union of Soviet Socialistic Republic, USSR or Soviet Union. And that was the only party. They were member of Security Council. Still, there were like Belarus and Ukraine had also representatives in UN. It was very kind of strange situation, but let's say Armenia didn't have. So technically, we had one country with 3 members to General Assembly and one permanent member in Security Council. Soviet Union was signing international treaties. Neither of the republic had international status to sign international treaties of cooperation or whatever. So Soviet Union was the subject of international law, was the country which was participating in international relations. Then this country kind of disappeared at one moment, and instead of this country, new countries appeared. So first argument is that the Nagorno-Karabakh Republic, as they called them at that stage after Artsakh Republic of Artsakh, also said, okay guys, you want to all be independent, I also want to be independent. Soviet Union constitution, Soviet legislation allowed this kind of activities. That's one argument. Second argument is that Artsakh...
So just to reiterate, even if Nagorno-Karabakh or Artsakh was an autonomous republic of Azerbaijan, the Soviet constitution gave...
of Azerbaijan Soviet Republic, which is not a republic. So I mean, it's very confusing, but let's say let's take United States. We have 50 states, and let's say one day they come together and say, just we want to dissolve. We don't want to be a big country. We want to be smaller countries. And then Northern California say, guys, listen, if you don't want to be part of that, I want to be independent. Then the Southern California would come and say, no, you can't be independent because the California became independent. The question is that Nagorno-Karabakh Republic never, even a single day, was part of Azerbaijani Republic. So it was never part of the Azerbaijani Republic, not before 2022, not after 91.
Yes.
So it can be that all together come together and then they dissolve, but after the dissolution, it happened that Artsakh became part of the Azerbaijan.
Okay.
Artsakh was not part of Azerbaijan in 18, 19, 20, 21. In Soviet, it was part, but it was again one big state. After dissolution, it was not part of the Azerbaijan. So there is a principle which says that principle of equal rights and self-determination of people.
Right.
It's very important. Nothing in the foregoing paragraphs shall be construed as authorization or encouraging any action which would dismember or impair totally or in part the territorial integrity or political unity of sovereign and independent states conducting themselves. And I will put a small pause here, I will continue. What Azerbaijan says, oh, you want to self-determine, if possible, maybe you will be some autonomy. Now they say no autonomy, I will protect all my citizens in full. Now let's continue here. In political unity of sovereign and independent states conducting themselves in compliance with the principle of equal rights and self-determination of people, as described above, and thus possessed of a government representing the whole people belonging to the territory without distinction as to race, creed, or color. People are speaking about separation for protection or separation for to save the people.
Yeah,
this is
salvation,
whatever we call it. So this is a principle which is very questionable. But what I'm telling the following: there is a racist country which called Azerbaijan, and now we have a case in International Court of Justice stating that Azerbaijan is a racist country. We have a terrorist state which is Azerbaijan, and at least I hope we do have, or we are in the process of having a case for hostage-taking convention, because Azerbaijan is holding people in jail, telling that they are whatever criminals, technically contrary to the November 9 agreement, because all the people captive should be returned, be it prisoner of war, be it
civilian,
whatever.
Exactly.
We have seen numerous European Court of Human Rights cases where Azerbaijan is in breach of their obligations. When someone was falling under the control of Azerbaijan, they were tortured. We have seen numerous of videos when people were beheaded. There is a mutilation of bodies. There are a huge number of international crimes. So Armenia should be very frank on this part. Armenia should be telling that Azerbaijan is a terrorist state, Azerbaijan is a criminal state, and we should be initiating, in addition to diplomatic, military, etc. activities to protect our sovereignty, integrity, etc., we should be initiating a criminal and international legal proceedings against Azerbaijan and be forcing on them. But be very frank, direct, and clear about activities of Azerbaijan. I have a feeling that today's government feels kind of guilt for Armenian activities in 91, 92, 93, 94. And they kind of have a guilt that, oh, we were bad guys and now we need kind of to shut up because we would be punished. No, we were not bad guys. We were acting in accordance for international law. There is 4 resolutions which Azerbaijan is always pointing. None of them is claiming that Armenia is an aggressor. Yes. None of them is claiming that Armenia has undertaken any international crime. It's just telling Armenians, if possible, please influence Karabakh forces or Armenians in Karabakh to undertake whatever activities.
Yes.
So clearly what happened now shows, and what happened in 88, what's happening now, it shows that Azerbaijan is a terrorist state and Armenia should be bringing this issue very clearly. And now coming back to where we started, because that's kind of the topic. What happened in Security Council? In Security Council there was statements, which is very important. The diplomats, politologists should interpret what a specific word stated there, what does it mean? Is it good? Is it bad? Is it in favor of Armenia or not? This is not my profession, and I really don't want to dig into nuances of specific words. I can guess, and maybe it would be educated guess, but I really don't want to get there. What is important? There is no legal document. What is important? Armenia should be pushing on instruments to show that Azerbaijan is an aggressor state. But just one small example, and then we will finish maybe for today, unless you have other questions. We have European Union observer mission in Armenia. If we go to UN Charter and we say, okay, what are the means? Because there are different means of the settlement of disputes. And in Article 33, it says that the parties to any dispute the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, this is OSCE Minsk Group, or other peaceful means of their own choice. And in practice, there is two very important instruments which is falling under this. This is third-party fact-finding missions. So technically, if
the
we
EU
look,
mission would be considered, yeah.
it can be, because you have a third party who is there, who is giving a report. However, I just followed 2 or 3 days ago, there was a publication that they finished their activities, no report would be published.
Yes.
So it's very strange. You have an observer mission which is observing, but is not stating any results. This is very important instrument, because third party observer mission, which is stating who is telling the truth, would be a very good argument to show in international relations. Armenia was bringing up for very long, and that was bringing up very long time, the concept, and that was in Kazan documents and then in other document, that we need to have border incident investigation mechanism. So
Yes.
this is very important instrument which is showing who started what. Because today Armenia is blaming that Azerbaijan is blaming that we started process, but this is not true. Azerbaijan is telling that Armenians are undertaking activities firstly, and unfortunately when we read the press statement from September 15 or the recent one, we can see that the reporter Miroslav Jenka is stating that one party said that the other party is starting,
Yeah.
the other party says that
They
the
said
third
we don't
party is
have
starting.
presence in the region, so we cannot verify.
So there is still possibility to bring evidence. I mean, you can do it unilaterally, you put cameras, you show who started, etc. But technically, if you have a mission, you
Yeah.
need to use it. If you have a mission of CSTO, you need to use it. If you have a mission of Azerbaijan, you need to use it. But for that,
Yeah.
it's very clear that Armenia should have a clear understanding. And here I see the main problem with Armenian government
Yes.
as a main responsible, as a citizen of Armenia at least, main responsible of not bringing up proper arguments, proper claims, proper requests to international actors to be able to protect the Armenian territorial integrity, Armenian sovereignty, Armenian rights of Armenian people. And that is where we really need to look at. Because everyone is guilty. If you listen to Armenian government, Russians are guilty. If you listen to Armenian government, UK is guilty. If you listen to them, Americans are guilty. Europeans are guilty. Everyone had their fault. You won't listen that Azerbaijan has fault, Turkey
Yes.
has fault, and Armenia has fault. Listen, if I am living in a country, not in an anarchy, I believe that the government is there to solve my problems. Otherwise, why I'm paying taxes, why I'm
Right.
paying my duties, etc. So technically, it's very important that the government has a clear understanding what they do. The elections of 21 were stating that government would have some position on Karabakh, on Armenia topics, but unfortunately, we don't see government following that, even that minimum standard which they set for themselves. So from that perspective, coming back, I think that international law, coupled with international diplomacy, economic diplomacy, social diplomacy, using diaspora possibilities, gives us a huge possibility to
Yes.
gain our legitimate rights. I'm not telling that we need to get something which is not ours,
Yes.
but this gives us a possibility to get a lot.
Except that we're not using those possibilities.
We are not using those possibilities because we don't want to use them. I mean, not we.
Yes.
Some people there don't want to use them.
Yes. Thank you for that clarification. And unfortunately, this was a very interesting discussion. We just talked about the UN. I had many more questions, and Mr. Orbelyan promised to come back, so I'm going to hold him to his promise. But this was a sort of very interesting deep dive into the UN and all the sort of possibilities that we could have. So thank you very much for that, Mr. Orbelyan.
Thank you for invitation. I will keep my promise whenever you invite me next
Okay.
time. I will be here.
We'll be very short. And this was a collaboration between Groong Podcast and 168 Hours. Please visit podcasts.groong.org or 168 AM to get more of this type of interesting and thoughtful discussions. Thank you very much.